Hi, this is Jack Beam from Beam Legal Team with Ryan Timoney. We're in our Chicago office today. I want to talk to you about medical records. When we get a call from a client, we take some basic information and then we get authorizations and we need to get the medical records. Now I'm going to reminisce a little bit because this gray hair is real and tell you about when I first started doing these kind of medical malpractice cases, specifically obstetrical and neonatal malpractice cases. There was no such thing as electronic medical records. Ryan here, because he's an engineer, we've designated him as the expert on electronic medical records, and indeed he has become one of the foremost legal experts on electronic medical records. But back in the old days, nurses were even writing with pencils. And since the beginning of these kind of cases, medical records have always been crucial, always crucial. But what has changed is the electronics, and what has also changed, and what I've noticed, is that when I was a young lawyer representing clients against hospitals and doctors, it was the exception when records were altered. Now it has become the exception when medical records are not altered or destroyed. And it was a rare thing. And every once in a while, someone would have done some funny alteration of records. But now it's really happening in not every case, but the incidence of it has just skyrocketed. And given that it seems to be this technology where nurses, doctors, residents think they can just hit delete and it's lost forever, but it's really not lost forever, is it, Ryan?
That's right, Jack. Like you've mentioned, electronic medical records, they've transformed how we have to do business, and they've transformed how the medical field operates. Specifically, I mean, everything's computerized, everything is automated, and there has to be a system in place to track what's happening, who's looking at records, who's adding to the records, what they're doing to these records. Because it's too easy and it's too tempting for nurses and doctors to go back and change what they previously wrote about the patient.
And we go in and fight to get the audit trails. And I think the courts are slowly starting to understand what an audit trail is. And in all candor, I didn't know what the heck an audit trail was maybe 3-4 years ago, but got educated pretty quickly. And so, Ryan, when we go in and we usually have to move to compel to force the hospital to give us the audit trails, and you've gone and argued this around the country in various cases we have around the country. What are you telling the judge, and how are you educating the court that may not know what an audit trail is?
So first of all, as you kind of alluded to, the hospitals never want to give these up. They never want us to get our hands on these things because of how much information is contained in them. And you've mentioned audit trails. The audit trails literally track every action that's taken in a patient's chart, in their medical chart. It tracks who accessed their records, who added to their records, what they did, where they were at within the hospital, and it tracks what they changed about it.
And there's something that you've taught me about, quite frankly, and that is a note revision history. Tell us about the note revision history.
Sure, and you mentioned that it's easy for doctors to go amend, alter, whatever word you want to use, modify the notes that they create in the record, and they think it's gone. And if nobody knew better, there's no way to tell, but we know how to get these note revision histories, and it's literally a side-by-side of every time a doctor or a nurse authors a note, it saves the version that they hit enter, and it's saved. And if they go in and modify it at a later time, we can see what they changed later in time.
And as an example of that, and we have a case here, I've redacted it. It was a confidential multi-million-dollar settlement that we got, and we got it in large part because of Ryan discovering about these missing notes. So there's a preliminary report and there's a final report. Now, just as a little bit of context, in the kind of cases we have where a baby has suffered hypoxic ischemic encephalopathy, lack of oxygen during labor because they didn't deliver on time, they didn't do a C-section when they should have, or they delayed a C-section. One of the ways you can tell if that baby's damage and injury was caused during labor is to have what is called a arterial cord blood gas. And that is a gas that's obtained. The cord is clamped before they cut it, and it's clamped on two ends. A needle's inserted, gases are withdrawn. And depending on what the values are, that can show acidosis, which is evidence of low oxygenation. So in this case, what did you find, Ryan?
When we request the records and we get the records, we see what the records look like in the end before they're modified. And they don't say anything about these blood gases. They don't say anything about the baby having acid in her blood and being hypoxic at birth. We get the note revision history and we find out that the note used to say that. And this doctor literally went and took that out of the records to cover up their tracks.
Did you argue that in front of the judge?
Yeah, and we had to go, like I said before, they don't want to give us these. We had to go fight for it. We had to go convince a judge and teach the judges because it's a new topic. A lot of judges they don't know that much about audit trails.
Well, a lot of those judges have gray hair like me too, right? So they're you know, they have Rolodexes like me.
They very well might.
They're not high-tech guys like you.
I just have a cell phone, you have a Rolodex. But it's true, we have to educate the judges about what these documents show. And this was one of the first times that we actually obtained these documents, and it's really difficult to explain to a judge when you don't have something to show them and you don't have an example to go off of. And
the defense will say, well, they're on a fishing expedition, Judge, they're on a fishing expedition. Well, in some ways, I guess we are on a fishing expedition for the truth. And when we finally did discover the truth, we were able to prove that the baby was hypoxic at birth based on that blood gas, right?
That's right, and it was a key component of the case. And I mean, it really helped us get the case resolved.
So that is the importance of electronic medical records and going deeper into the audit trails. The lawyer has got to do that, and we're on that every time, and I think we're on the cutting edge of it. Hopefully, eventually, judges and everyone will be a little more knowledgeable about it, as I myself learned with a little edification from Ryan here.